Good afternoon to you all. I would like to begin by thanking Betsy in particular and the American Society of International Law for inviting me to share some of my thoughts with you this afternoon. I'm delighted and honored to hear the American Society of International Law, with the foremost international law organization of academic and practicing international lawyers. I have been a member of the society since my student days. I've benefited a great deal from the work that the society does and is able to produce. And it's a real honor and feeling that having the opportunity to come and speak to you about the work that I do currently in my capacity as the United Nations Special Rapporteur for Human Rights in Cambodia. What I would like to do, go through very briefly what do the special rapporteurs actually do and what I have been trying to do in Cambodia myself as the country rapporteur. The institution of the special rapporteurs, in my opinion, is a rather unique institution. Hence, the name itself within the United Nations system is called special procedures. It's a rather special mechanism. There are no other mechanisms of this nature which can actually pierce into the veil of national sovereignty of the states. We are basically appointed to look into the internal affairs of the states. Those of you who are familiar with the Charter of the United Nations, paragraph 7 of Article 2 doesn't allow member states of the United Nations to interfere in internal affairs of another state. But here, since the standard setting after the adoption of the Universal Declaration of Human Rights and elaboration of the principles enunciated in the Universal Declaration through the 1966 Covenant on Civil and Political Rights, Economic, Social and Cultural Rights, the United Nations Human Rights Mechanism moved to the next phase. That phase is characterized largely by the phase of implementation. Having set the standards, the time had come, rightly so, to look into different ways and means of implementing the human rights standards developed through these universal instruments. So, special rapporteurs, in my opinion, are part of that package. In some form, special rapporteurs have been in existence since 1960s, but the number grew as and when the situation of human rights got worse in different parts of the world. There are two types of special rapporteurs. One are called thematic special rapporteurs, who will have a global mandate, but they will focus on a narrow theme, a particular human rights issue. For instance, right to education, right to health, violence against domestic violence against women, all sorts of different areas. They are thematic special rapporteurs, and there are some 7-8 of us, which I call them endangered species, because the number has been dwindling since the late 1990s. Today, there is a slight reversal in the process. Within the recent past, we have seen the creation of 2 new mandates, one for Iran and one for Syria. That's an encouraging development. But going by the data, in the late 1990s, there were about 26-27 country rapporteurs like me. But these mandates have gradually been abolished. The United Nations, as you know, is a political body. Human Rights Commission that existed until 2006 was a political body. And the Human Rights Council that is in existence today is a political body. So those states, no state to my knowledge likes special rapporteurs. And those states who can garner enough support within the Human Rights Council will do their best to abolish the mandate itself. As a result of that, one number of mandates have been abolished. Some of them, in my own opinion, should not have been abolished, but have been abolished. But again, as I said, there are 2 new mandates created for Iran and Syria. So there are some encouraging indications as well. The mandate of the country special rapporteurs like me is a rather broad one. We cover the depth and breadth of human rights issues in the country concerned. we have to live up to rather high expectations on the part of the normal people, the ordinary men and women in the street. People who have been affected by human rights violations will go to the judiciary. If they do not get effective remedy, then they will knock on other possible doors within the state structure. If they do not get any remedy after trying all these different institutions, they will think the special rapporteur can do something for them. So we are seen in many parts of the world as the ultimate resort. And people do send to us individual petitions. Although the special rapporteurs, in my opinion, are not designed to entertain individual petitions. The institution of a special rapporteur is not a judicial body, not even a quasi-judicial one. Although some people have characterized it as a quasi-judicial institution, hence some of the functions, fact-finding, so on and so forth, which may ultimately lead to criminal prosecution. But the people who are living under oppressive, autocratic, dictatorial regimes think that the special rapporteurs can do something for them. Hence, for instance, in my own case, I do receive quite frequently individual petitions from people whose rights have been violated. But we are not ready, or we are not resourced enough, or don't have the powers to exercise, entertain those petitions. Having said that, on the basis of the information received, we can make a representation on behalf of them. Sometimes intervening directly at the highest level possible, sometimes writing to appropriate authorities, and sometimes verifying the information and then including the information in our annual report which we submit to the United Nations Human Rights Council. Sometimes we can be very effective. Just the fact that the matter has been brought to the attention of the special rapporteur will deter the authorities from going further. It has been brought to the international attention. The special rapporteur is concerned about it. The special rapporteur is taking some initiative. That message alone may do the job sometimes. And in many cases it has done the job. It is not an internal matter anymore. It is an international matter. But then within the United Nations system itself, the expectations of the special rapporteur is rather high. I will just summarize very briefly the role we are expected to perform as a special rapporteur. Are 6 different things rolled into one. Number 1, we are supposed to analyze the relevant thematic issue or country situation, including undertaking on-site missions. Number 2, advise on the measures which should be taken by the governments concerned and other relevant actors. Number 3, alert the United Nations organs and agencies, in particular the Human Rights Council and the international community in general, to the need to address specific situations and issues. In this regard, they have a role in providing so-called early warning and encouraging preventive measures. 5th, advocate on behalf of the victims of violations of human rights through measures such as requesting urgent action by relevant states and calling upon governments to respond to specific allegations of human rights violations and provide redress. 5th, activate and mobilize the international and national communities and the Human Rights Council to address particular human rights issues and to encourage cooperation among governments, civil society and intergovernmental organizations. Finally, follow up to recommendations that we may have made. So as you can see, there are 6-7 type of activities that we are supposed to carry out. So in other words, the special rapporteurs are supposed to be an academic, an advisor to the government, because if you look at the resolutions of the United Nations, the resolution on special rapporteurs comes under capacity building, cooperation. So assisting the government to improve the situation of human rights. Moving away slightly from the traditional perception of special rapporteurs, that is basically naming and shaming. These days the expectation within the United Nations system is cooperation in a constructive manner, identifying the deficiencies and weaknesses that exist within the system and advising the governments how to improve the situation of human rights. So advising the government, advisory role, researching, and acting as a rallying point for various NGOs and INGOs working in the area of human rights. So representing their interests and putting them to the government and to other international organizations. So you have to be at the same time an academic, an activist, an advisor, and an advocate. So 4 or 5 different roles you have to play. When I go to Cambodia, in my own case, that is certainly the case. For instance, the NGO community, INGO community would like to see me and express their concern so that I can represent their views to the governmental authorities when I have a meeting with them. And groups of individuals, people whose rights have been violated can also come to see me. I have a habit of making it be known through the media that I will be in the country. As a result of that one, I do receive some individuals whose rights have been violated or groups of individuals. I will discuss later some of the main human rights issues, those affected by land rights. In Cambodia is one of the biggest problems. Land rights, I have had the delegations of 70, 80 people coming to see me in my small office, cramped, but women, elderly, children, those who have not had any protection from any state agencies created. They have been asked to evict the land or the property they have been occupying for a long time. And they are desperate for some protection. That's just an example. Then the method of work, how do we carry out our work? I'll run through very briefly. First of all, we receive information from different sources. Individuals, international organizations, national organizations, NGO, INGOs, diplomatic missions, foreign diplomatic missions in the country. For instance, when I go to Cambodia, every time I have a group meeting with all the ambassadors based in Phnom Penh. They will come to see me collectively. Then some of them will also ask for a private meeting, bilateral meeting. Then I make myself available to see those who have something concrete, meaningful to say to me. So bilateral meeting. Then acting on information, on the basis of information we have received, whether it is including in your report to the Human Rights Council or picking up the phone to talk to some minister or another state authority or the person relevant within the state mechanism. Then if we are not satisfied with the outcome or with the response received from the government side, then we can do one of the following 2 things. Number 1, write urgent letters in a systematic manner. Look, this is the information I have received. On the basis of that one, I am concerned and I would like you to respond. That's one. The other one is a letter of allegation. Once the human rights violation has occurred, then pointing out that the violation has occurred and the country is in breach of certain international human rights standards flowing from a treaty the country is a party to. That letter we sent out. And if that is also to no avail, even after formal communication has been sent, no response, then you issue to the media. Then you say what you have to say through the media, putting the government on the spotlight, which not many governments around the globe would like to see. Hence, there is a pressure on them to respond. Although I have been told that some governments have a habit of responding regularly and immediately after they have received the communication from the special rapporteur for a standard letter. We are aware of it, we are doing our best, of no substance. But sometimes the government do respond with some substantive response. If they don't do so, then the special rapporteurs will go public and put the government on a spotlight, issuing press statements and some other forms of public denunciation of the action of the government. Then other activity we carry out country visits. Both thematic and country mandate holders are expected to make at least 2 visits per annum. Although in my case it has been sometimes 3 visits because of the urgency of the matter or because of the complexity of the issues involved. Sometimes I have made 3 visits to Cambodia, but I have made minimum of 2 visits. Then on the basis, the visits are designed to ascertain information, verify the information you have received from different organizations and individuals. See for yourself. For example, I will give you an example. When I was in Cambodia once, I went to see the governor of Battambang province, which is bordering Thailand to the north. When I had finished the meeting with the governor, I hadn't given them any idea that I intend to go and see for myself the detention center. After having a pleasant diplomatic meeting with the governor, I said, from now on, thank you for receiving me, thank you for your time, can I proceed to the detention center here? Not giving them any opportunity to do any cover-up. And he couldn't say no. And from then onwards, within 10 minutes, I was able to go to the detention center and see for myself who are the people kept there. That sort of thing you can do when you are on a country mission. And then once you have received the information from various sources, from your own mission, then you come to the reporting stage. Reporting number 1 to the United Nations Human Rights Council, and you will report about 10,000 words. We have a word limit, like students have at my university at Oxford. We have 100,000 word limit. We have our own word limit. We may like to submit a longer report, but the United Nations system is very strict. The translators, the editors, copy editors would not look at your report if it is more than 10,000 words. So it's about 10,000 words. After editing, may go to about 200, 300 words, but that's roughly the limit. Within that limit, we submit our annual report. Once the annual report is in, then we go to address the plenary session of the Human Rights Council once a year. You can ask for another opportunity halfway through the year, but normally it is once a year. That's what the convene would have been scheduled for. Then you summarize your report and present an update on the situation in the country. Then respond to any questions the members of the Human Rights Council or any other member state may have, because the floor is open to all member states of the United Nations. Actually, on most occasions when I have addressed the Human Rights Council, almost all member states of the United Nations have participated in the debate, and it's called interactive session, during which they can ask you questions, then you respond to them. One good thing about the interactive dialogue, which was not in practice, I think in the 70s and 80s, these days NGO, INGO representatives themselves can be present in the meeting hall and ask questions. And they are the ones who ask quite challenging, sometimes difficult questions, tricky questions. But you have to be prepared for that one. And once you have done that one, the country concerned has to respond. Sometimes they may just denounce the work of the Special Rapporteur, even criticize the Special Rapporteur, denounce the Special Rapporteur, all sort of things. For instance, North Korea is an example, which has never let the Special Rapporteur of the country into the country. Myanmar or Burma sometimes has let them in, sometimes delayed, applying all sort of delaying tactics. So far as Cambodia is concerned, so far they have not declared me persona non grata. So that I regarded as success. My predecessor was at the bottom, being declared as persona non grata. He had a difficult relationship with the government, and I had a very hard act to follow. So that's why, on the basis of that one, that the state will have to respond. And now, thanks to the existence of the UPR mechanism, Universal Periodic Review, our work can be integrated into the UPR process. Although the United Nations system hasn't moved on that far to integrate fully the work of the Special Rapporteurs, but during the UPR process, our report can be integrated, recommendations can be integrated, or vice versa. For instance, if the UPR recommendation is about calling for reform of the judiciary, then what do we mean by that one? Then our reports will have gone to outline in detail what do we mean by the reform of the judiciary, how to make it more independent, and how to enhance its capacity. That's very briefly the nature of the work we do with the Special Rapporteur. Now, my own situation, what I do in Cambodia. I was appointed in March of 2009. Then I undertook my first mission to the country in June 2009. That mission was basically a diplomatic familiarization mission, because I wanted to establish links with the government, build the bridges that had been broken, so that whatever I do will be brought to the attention of the government directly. After I finished my first mission, I realized that my approach could be a different one. The country mandate for Cambodia, in my opinion, is one of the strongest for two reasons. Number one, the mandate is based on the resolution of the Human Rights Council. Number two, as you know, Cambodia went through 30 years of political conflict. When the Paris Peace Accord were concluded in 1991, there was a provision included in the Paris Peace Accord itself for appointment of a human rights special rapporteur for the country to make sure that three pillars of the new architecture for the country, constitutional political architecture, democracy, human rights and rule of law, were implemented properly. So the mandate also derives partly from the Paris Peace Accords. So even if the government, strictly speaking, even if the Cambodian government were minded to abolish my mandate or try to garner enough support within the Human Rights Council, some council members can take a rather strict position, legalistic position, say we don't have the powers to abolish this mandate because it derives partly from the Paris Peace Accords. Since the mandate is quite a strong one from a legal perspective, I thought, and again, I am not the first special rapporteur for the country, beginning with Justice Michael Kirby, a very distinguished jurist from Australia, and a long line of distinguished jurists have served as a special rapporteur for the country, previously known as the special representative of the Secretary General himself. And when the Human Rights Council streamlined these various mandates, all of us were called special rapporteurs. Although people thought it was a bit of a downgrade of the mechanism, but not necessarily so. Whatever they could do as special representatives of the Secretary General, we special rapporteurs can do. As far as the mandate is concerned, it has not been narrowed down. When I looked at the work of other special rapporteurs, I could have chosen any of the burning issues of the day. For instance, in Cambodia, as I said, so far as the ordinary men and women in the street are concerned, land rights is number one. Then comes to freedom of expression. Then comes to the independence of judiciary. Then comes to a number of other human rights issues. I thought I could revisit some of the issues and try to make my own contribution to strengthen the situation within that particular theme. But then I looked at the Paris Peace Accords themselves and the Constitution of Cambodia. If you look at the Constitution of Cambodia, since it was written when the United Nations had a heavy presence in the country, soon after the conclusion of the Paris Peace Accord, the Constitution is a democratic one by and large. It's a democratic framework. So what is the problem there? Then I looked at the state institutions created to uphold people's rights. Then I realized the problem was with the institutions themselves, rather than with the Constitution. A plethora of institutions have been created. For example, if you look at the constitutional framework in Cambodia, you have the judiciary, you have the Constitutional Council, you have the Supreme Council of Magistracy, you have now the anti-corruption body, you have even Human Rights Committee, although it is not as independent as some other human rights commissions elsewhere, but the mechanism is there. But what have these institutions been doing? How have they been handicapped? What are they lacking? I thought my approach should be a different one. Rather than looking at each and every thematic human rights issue, I would look at institutions, institution building, capacity building, building the capacity of these institutions. And you will not be surprised, I as a person with a legal background, the first institution I decided to look at was the judiciary. I thought the problem here was the land rights, whether freedom of expression, freedom of assembly, any other things. Ultimately, people had to go to court and expect to get speedy and impartial justice. Why they were not able to get it? What was the problem with the judiciary itself? Then I analyzed the system in greater detail and came up with a report which is now with the government, and in which I have made a number of recommendations. First of all, many of you with a judicial background would know, if you are a judge, if you are handing out a judgment today, maybe against the powerful of the society, could be militarily powerful, economically powerful, politically powerful, you must be able to have a good night's sleep, thinking that my job will be safe tomorrow morning. Isn't it? That gives the judges the confidence to deliver justice, those who want to dispense impartial justice. That can be provided by a piece of legislation, regulating the terms and conditions of service of the judges. What I realized in Cambodia, that very instrument, that very piece of legislation was missing. No, judges are treated as civil servants, right? Not having, unlike elsewhere, not having a separate piece of legislation to guarantee the terms and conditions of service, providing the minimum safety and security that they will require to dispense impartial justice was not there. So number one recommendation was that one. Actually, that was required by the Constitution. When the Constitution was promulgated in 1993, it mandated that such a piece of legislation be enacted as soon as possible. But I was looking at the judiciary in 2009, 2010, nearly after 2 decades, the legislation had not been tabled before Parliament. Once you don't have that piece of legislation, it is easy for the executive to maneuver the situation, to intimidate the judiciary, harass the judges, and the judges themselves would not have the confidence that they would have if they had the protection. So that was number one. Number two, who has the powers to appoint judges? Very much depends on that one. How the judiciary, how the judges are able to perform. In Cambodia, a constitutional body known as the Supreme Council of Magistracy is the one which has the power to recommend for the appointment of judges. I thought that itself should be looked at. How independent it is in the first place. Before you talk about the independence of the judiciary, who appoints the judges? And I looked at that one, I realized that there were some problems within the structure and composition of the Supreme Council of Magistracy itself. So number two recommendation I made was to reform the Council of Magistracy itself, so that it can recommend competent, independent, impartial people as judges for appointment as judges to the judiciary. And third thing I looked at was, in most countries, when you have a judiciary, there is a separate organic law. That's what is called in Cambodia. Organic law defining the powers and functions and vis-a-vis different other institutions within the country. That organic law itself was missing in Cambodia. So 3 core pieces of legislation which should have been there soon after the adoption of the constitution were not enacted. There were attempts were made in the late 1990s, but for a number of reasons, the executive was not proceeding with the process of reform, the process of democratization. Even though mandated by the constitution, these legislations not tabled before Parliament. So I thought I should encourage the government and push them as much as I can. Look, these are the laws required, mandated by the constitution, and in my opinion, as the United Nations expert for the country, I would like to recommend the following. So these are 3 core recommendations, and there are of course a number of other recommendations I have made. For instance, increasing the resources for the judiciary, not only the judges but also the prosecutors. These days, to carry out effective investigation for any prosecutor, for any law enforcement agencies, investigating authorities, you need to have the resources available in terms of financial or other forms of resources. The judiciary, I heard in Cambodia, was chronically underfunded. So I recommended that the budget for the judiciary should be increased. So did long list of reports. I didn't have time to go into all of them, but about 30 or so recommendations I have made with regard to the judiciary. And then when I presented that report, one good thing in Cambodia, more or less every time I go there, I have the opportunity to meet with the Prime Minister himself. And then I have sometimes a 2-hour meeting, sometimes 2.5-hour meetings, reviewing the situation within the country and conveying my own concern. And on the basis of that one, I was assured that a committee would be established to look into my reports. And promise was made to me that these 3 pieces of legislation would be tabled before Parliament as soon as possible. What is as soon as possible? 3 months, 6 months, 3 years, remains to be seen. That's what I'm still pushing. And every time I go there, I do keep reminding them that these laws should be enacted as soon as possible. Some of the recommendations I have made actually came from some senior members of the judiciary itself. You know, in life, we all would like to do a good job of whatever we are supposed to be doing, and there are some judges who are really interested in strengthening the capacity of the judiciary, independence of the judiciary. Some of the recommendations I have included came from them, saying that it would be very helpful if you were to include the following recommendations in your report. We cannot say so, but if you can speak for us, would help us a great deal. So it actually came through consultation within the members of the judiciary itself. And of course, speaking to other stakeholders in the society, NGOs, and a number of other organizations in the country. After completing my work on the judiciary, I moved on to the legislative body. To what extent has the legislative body been able to hold the executive to account for human rights violations in the country? Before you go to the judiciary, people should be able to go to their MPs. For instance, I reside currently in the UK, or even when I go back to my native country, Nepal, if I have a problem, I have two options, either going to my local MP, asking for help, or knocking on the door of the judiciary. But in Cambodia, how does it work? Why these people aren't getting any effective remedy? Nobody is protecting the people. So I thought I should look at the structure and independence of the legislative body. And there also I came up with a series of recommendations designed to strengthen the capacity and independence of the legislative body to hold the executive to account. That's number two. And the third thing I have done is, after looking at all these human rights issues, I could have gone on to look at some other state institutions. But in view of the commune elections forthcoming, actually in a couple of months' time, July this year, and the national election, parliament elections due in the summer of next year, I thought I should look at actually many people who came to see me. When I go there, I have a habit of meeting with leaders of different political parties, including those in opposition and in government, and those political parties which have some representation in parliament. Even those who do not have any representation in parliament can still come to see me. On the basis of the information I received and the request I received from many of them, I thought I should look at the electoral laws themselves, election commission or election committee. That's also another state institution responsible for upholding people's right to democratic governance, to guarantee the right under the ICCPR 1966, number of other international human rights instruments. So if the election process itself is not going to be credible and fair and free one, then people's right would be violated. So I thought, applying that human rights perspective into my work, I thought I should look at the election commission, the electoral laws and practices in the country. What I have done, I was in Cambodia in December, and I intend to go back again in May if all other things work out well. In December, I looked at the work of the National Election Committee. Normally, in many countries, not only developed countries, but in developing countries as well, the National Election Commission has an independent autonomous status within the constitutional framework. It's a constitutional body, not a governmental committee. So what is the status of the election committee in Cambodia, number one? Number two, people have expressed various concerns to me about the process, which is unfair from the very beginning. So for instance, some of the examples they give me was the voter registration process. Who is eligible to register as a voter, who is not eligible? And once you are registered, do you have to have your registration renewed every time the election is coming? Number of issues relating to voter registration were brought to my attention, and I thought I should address their concern as well. So what I have been doing, looking at the composition, the capacity and the independence of the election committee, voter registration process, access to media, equal access to media related issues, and also the use of state institutions, state machinery, neutrality of the civil service, neutrality of the police and army. These are 4 or 5 different issues I am examining very closely, looking at the practice in other countries in general and within the immediate neighborhood of Cambodia in particular, so that whenever I am using examples, I can give relevant examples. Not something imported from the USA or UK or more advanced democracies, but less advanced democracies where Thailand, for instance, elections have been conducted by and large freely and fairly. After the recent elections, not many opposition party members were able to challenge the credibility of the elections themselves in Thailand. Although the country is going through different political phases, but at least the elections themselves. Of course, there will always be losers in developing countries. You will always say, oh, the votes were rigged, so on and so forth. But again, in Thailand, that is the case. So in other countries in the region, since Cambodia is a member of the ASEAN, and the ASEAN is moving towards adopting a regional human rights instrument, some progress is there. And today, actually this year, Cambodia happens to be the chairperson of that ASEAN organization. Then, using some examples from the neighboring countries themselves, I thought I will make my argument more powerful. Of course, I am looking at the work of the election commissions in other leading developing countries. I have selected 5 countries from 5 different geographical regions. Australia, because of its geographical proximity. Actually, I thank you, Betsy. I am Vice President of the Asian Society of International Law. Prior to that, I was Chief Editor of an annual Asian publication called the Asian Yearbook of International Law. And we were asked to define what do we mean by Asia, and we have had a habit of excluding Australia and New Zealand. But now, within the Asian Society of International Law, they wanted to join us, and our definition of Asia includes Australia and New Zealand as well. And we are very happy to have our distinguished Australian and New Zealand colleagues within the Asian Society of International Law. So Australia, India, Brazil, and Zambia. These are the countries I am looking at, presenting a comparative picture, and then whatever recommendations I will be making will be based on the analysis, comparative analysis of the laws and practices in these countries, and then what ought to be done to make sure that the elections are credible as possible, and free and fair, both common elections and national elections. That's what I am trying to do. Now, what are the main human rights issues of the day? Number one, as I said before, is land rights. That's what, even when I am looking at the judiciary, even when I am looking at the legislative body, even when I am looking at the electoral process, the ordinary men and women in the street, especially the poor of the poorest in the villages are concerned, their number one concern is land rights. When the Khmer Rouge were in power, many of you would know, the estimates vary from 1.7 to 3 million people who are killed. Different estimates have different figures, but that's roughly within that range. Many people were forced to leave the capital city Phnom Penh. Many people fled the capital city. Many people actually fled the country. When they came back, of course they had to occupy whatever they could. And since the utopian idea that the Khmer Rouge had, that in order to make a new start, everything that existed had to be destroyed. So systematic destruction of state institutions and the records kept by state institutions were destroyed. And the people who would look after the records were also killed. So the people is targeted, for instance, many of us in this room will be the number one group targeted by the Khmer Rouge. Those who had anything to do with law, human rights issues, judiciary, academics, professors, journalists, people who wore a glass look like people who read books who were killed. That was the systematic attempt to abolish any opposition to that extremist leftist regime. As a result of that one, not having a proper record kept by the government itself, and individuals when they were fleeing the country, fearing for their life, the last thing they would bother about having a piece of paper in their pocket that some land they were leaving behind belonged to them. So the people didn't have any proof to suggest that something belonged to them. They owned that, or the government itself not having that system. So when they came back, of course they had to settle wherever they could, they had to occupy whatever they could, and they started living wherever they could. But now the government has embarked, like elsewhere, development means building high-rise buildings, big complexes, mixed complexes, residential and commercial, so on and so forth. The development means big infrastructure. Of course, building roads, hospitals, colleges, universities is a necessary thing. But again, other things also highly desirable from commercial perspective. So as a result of that one, the government has been trying to acquire land from the people and asking them to leave the land they have been occupying for a long time. And especially those who are rich in terms of political power, money power, military power, have a tendency to grab land, especially in the villages. They will go and produce a piece of paper saying that such and such piece of land belongs to them and asking the villagers to leave. Actually, I have gone out of the Phnom Penh city to interact with people evicted from their land in very many rural areas and spoken to them for myself, so that I am not relying on secondary information. So when I am talking to the Prime Minister or the Prime Minister or the Minister responsible for land management, I am speaking on the basis of first-hand information. I go and meet with the people, take personal witness statements from them, and relying on that one, I make a representation. What is going on is not acceptable. Full stop. Either new institutions have to be created to deal with land disputes, or the judiciary has to be made independent enough and should have the capacity to deal with huge range of land disputes. not having, the judiciary has not been able to command the respect, trust and confidence from these people. So many people would not necessarily bother going to courts, will actually camp outside the residence of the Prime Minister, or sometimes go to see some other ministers in delegations, but to no avail. So new institution, new mechanism has to be created to deal with land-related disputes, number one. Number two, in Cambodia, freedom of expression has been a problem. Both, well actually three: defamation, disinformation and falsification of information. These are the three tools employed by the executive to silence the opposition, to silence opposition party people, to silence human rights defenders, to silence people working for NGOs. Cambodia is a country which has a civil law system, basically, especially with regard to criminal justice. With regard to commercial matters, they are moving gradually towards a common law system, but the criminal justice system is based on the civil law system, within which defamation is a criminal matter. So if it is a criminal matter, you can be prosecuted and sent to prison. Thankfully, because of the work done by my predecessors and a number of other people, defamation is no longer punishable by prison sentence, but is still a criminal offence. So you can still attract heavy penalties. If you don't pay the penalty, you end up going to jail. And that instrument has been employed against human rights defenders, against NGO people, and against the members of the opposition parties in parliament. So a couple of MPs have been subjected to this instrument, and as a result of that one, their parliamentary immunities have been lifted, and they have not been able to function as an MP representing their people. So I thought I should look at that one, and I also did a comparative study. One of the things I have done, since I was able to meet with the Prime Minister myself a couple of times, I said to him, in addition to the annual report I will be producing, I will be sending you briefing notes on a regular basis. As and when I thought some concrete action had to be taken on a number of human rights issues, I will be sending you briefing notes. One of the briefing notes I sent was on the freedom of expression. How inadequate the provision in Cambodia was, or how some of the provisions in the Cambodian law inconsistent with Cambodia's international human rights obligations, deriving from the human rights treaties ratified voluntarily by Cambodia. So my approach has been to a certain extent a legalistic one. When I went to Cambodia, once I was told by somebody high up in the government, well, human rights agenda is a Western agenda, you have to come to promote that agenda, isn't it? Then my response was, I don't know about Western or Eastern agenda, but you are a member of the United Nations. By joining the club called the United Nations, you have agreed to abide by its own rules, and one of them is respecting human rights. And you have done so through the ratification of a number of human rights instruments. And I am here to make sure that you live by your own promises made to the people through the ratification of these instruments. That's it. Nothing more, nothing less. And that person was silent. So I have taken a rather legalistic approach, because as I said, the constitution is by and large a democratic one. Cambodia has ratified a number of international human rights instruments, and these instruments should be implemented properly. Where they have not been implemented, it is my responsibility to point out and then suggest a way forward. The approach I have taken in Cambodia, which I have characterized as constructive approach, not necessarily naming and shaming, but giving my own recommendations, what ought to be done. Of course, it's a developing country. It has its own challenges. Before I started to work as an academic in the UK, I used to work for the judiciary in Nepal. So I was working for a Royal Commission on Judicial Reform. Some of the issues that I was grappling with in Nepal long time ago are very similar to the situation the people are grappling with in Cambodia today. So not only speaking on the basis of my experience and expertise of work in a developed country, but also applying my experience of work in a developing country, I have been able to persuade them. These are the recommendations that I am making as a friend of Cambodia, as a friend of the people of Cambodia. These ought to be done if you want to accelerate the process of democratization, if you want to live up to the expectations of the people within the country. The following are the recommendations I would like to make, and I would like you to implement them. And when Cambodia's UPR took place, thankfully many of the recommendations made after the UPR process included my own recommendations. So I was pleased to see that incorporated into the UPR recommendation. So now even if they can rubbish me, dismiss me, of course they do, governments around the globe, I do go there, and when I am there, the government utilizes its own media to rubbish me, dismiss me. Oh, the United Nations people come on long holidays and enjoy time and criticize us. You know? That's the allegation. Actually, the Prime Minister himself made once in relation to my predecessor. So that's the situation. Demonizing, criticizing, rubbishing, discrediting. That's the reason we have to be as factually correct as possible. That's why before you say anything, although many people have very high expectations, different expectations of you, if you stand on solid ground, on concrete evidence, if possible gathered by yourself, first-hand information, then you can stand your ground and argue your case. And that's what I have been doing with the government. Because they have been dealing with the United Nations machinery for a long time. They are very skillful how to play with the United Nations institutions. So I have to be very careful there. And of course, I am here working on behalf of the United Nations. If other countries were not supporting me, I would not be able to do the job. When I see the ambassadors, foreign ambassadors based in Phnom Penh, that's what I say. I invite them like we are here today in a meeting room and say, look, what I am doing here is on behalf of the United Nations. You are the United Nations. If you don't help me, if you don't raise some concerns, when you have a meeting with the Prime Minister, Foreign Minister, asking difficult questions, by the way, what have you done with the recommendations of the Special Rapporteur? My reports will not go very far. And thankfully, some of the ambassadors have been able to do so. I have had some positive feedback that they have been able to point out that these are the recommendations made by the Special Rapporteur and the Human Rights Council and the UPR. What have we been doing about it? Or sometimes even before sanctioning a bilateral aid package, you know, asking that sort of questions. Especially, I asked them to do so. Most developing countries have an annual meeting, so-called donor community meeting. When they have that donor community meeting, that's where they can ask these questions. What have you done with these recommendations? UPR or Special Rapporteur's recommendation. So working in partnership with international actors based in Phnom Penh, working with the government, civil society representatives, opposition parties, is a very tight rope that you have to walk, making sure that your three things govern our activities. Although Special Rapporteurs, you know, how they perform is basically down to that individual. But we do have overall guidelines, code of conduct. If I may summarize, 3 words sum up our activities: impartiality, independence, and objectivity. So if we are able to maintain these 3 standards in our work, then we will not be able to challenge. And so far, the government may not be happy with me, may criticize me or my approach, but they have not been able to challenge me either in Geneva or in Phnom Penh, either in public or in private, on my recommendations or on the facts that I have included in my reports. Because I have gone through certain length and certain pain to make sure that whatever I have documented, documentation of human rights violations are based on credible facts. So on the basis of that one, I have made, I must say, I have made some progress. In life, I believe that making a small difference is better than making no difference. You can't make a big difference doesn't mean that you have to give up making a small difference. A small difference you make makes a huge difference to some people. There has been some progress made. For instance, I will give you an example. When I started my work in Cambodia, there was no package of compensation as such in place for the people being evicted from their land. That was one of the first concerns I expressed. I said, in this 21st century, no people should be evicted from their land, no matter how they got there in the first place, but they should be compensated if they are genuine occupants of that land or property. So there is now new law on expropriation under which the package of compensation is there. Another example, right in the heart of Phnom Penh, the capital city, there is a huge area called Bangkok Lake. About 700-800 families were affected. They were on the verge of being evicted. The land had been given to a developer. They were going to build a mixed housing complex for commercial purposes, residential purposes, and the people were not being compensated. Every time I went to Cambodia, they were the first ones to come to see me. Various groups, sometimes large groups, sometimes small groups, sometimes individuals. I was rather touched by their plight. Then I intervened at the highest level possible and I argued my case. Thankfully, the World Bank chipped in, and so did a number of other international stakeholders. As a result of that one, in September last year, we saw some sort of negotiated outcome of that problem. So about 700 families were included in the deal with the government, whereby they would have three options: either opting for an apartment that will be built by the developer on site, or relocating themselves to a site elsewhere, or accepting a practical monetary compensation. What my disappointment is that the package was not broad enough. It excluded some families, about 70-80 families. They are my concern. So when I went back to Cambodia, I saw them again. I am driving my message home on their behalf as well, saying that it should have been more inclusive, so on and so forth. The implementation also hasn't gone terribly well. The deal was done, but the deal, the way it has been implemented, I have some concerns. But at least some progress was made there. And the third example I will give you was, many of you here, including Claire, will perhaps shed some more light on the endeavor that we all made. Cambodia was about to enact a new law, so-called NGO law, to tighten the screws on the NGOs, basically making it difficult to receive donations or support from international agencies to carry out the work in Cambodia. One of the things I had asked the Minister of Interior, who is the Deputy Prime Minister, during my second mission, that in these days, when you are enacting a law regulating the activities of NGOs, the NGOs themselves should be consulted. And I asked him to give me a clear commitment that they would be consulted. Any law these days, if it is about NGOs, they should be consulted. So he gave me that assurance, and many other people must have said the same thing, I am sure, to him. And as a result of that one, for the first time in the history of Cambodia, the government decided to carry out a process of consultation before tabling the legislation before Parliament. But when we looked at the draft legislation, we were not happy with some of the provisions there. You may carry out a consultation, but that consultation may not be a meaningful one. You may listen to people, but not hear the message. So I thought that was the case here. So we again applied our pressure as much as possible, and then as a result of that one, the Prime Minister or the Cabinet has now returned the bill, draft bill on NGOs, to the Ministry of Interior for reconsideration, and another round of consultation took place, I think, in January. So now the bill is unlikely to proceed, unlikely to become law in the foreseeable future. Of course, there are all sorts of considerations here. Some people say that Cambodia is a candidate for election to the Security Council as a non-permanent member. It is now chairing the ASEAN, so politically not so opportune time for them to push ahead with this legislation. But at the same time, our pressure may have also worked, and there may have been other factors taken into account. When weighing the pros and cons of such a measure, they must have realized that perhaps the time had come. And of course, my position was slightly different, I must say here. I will give you an example. Some foreign governments were of the view that the Cambodia did not need or should not enact the law in the first place. But I, as an international lawyer, I could not challenge the power of a sovereign state to enact a piece of legislation if they wanted to, in any area. That's what Parliament is for. But my position was, you are free to enact a new legislation, provided that the provisions in the Constitution do not contravene your international obligations flowing from international human rights treaties. If the provisions in the new NGO law are consistent with the provisions in the Constitution of Cambodia itself, and consistent with Cambodia's international obligations flowing from international treaties, I have no problem with it. And some of the provisions proposed were, in my opinion, not consistent with Cambodia's obligations on the international human rights treaties, and not even consistent with Cambodia's constitution, which, by the way, guarantees freedom of assembly and expression, so on and so forth. So as a result of that one, the draft bill has been returned to the Ministry of the Interior for reconsideration, and as things stand today, is unlikely to be tabled before Parliament in the near future. So these are some of the examples I can give you. I have had a number of other successes. For instance, on a number of occasions I intervened on behalf of particular individuals. I spoke to the Ministry of Interior, I spoke to the Ministry of Justice, I spoke to the Ambassador in Geneva. As a result of that one, the situation was somehow remedied, or at least the people got some protection thereafter. So that's basically what I have been doing in Cambodia, and thank you very much for coming to share your views and listen to me this afternoon. I'm delighted and honored to be here, and thank you for your participation. And the idea of a a small discussion group like this one is opposite to a big lecture theatre, one person talking from the one end of the hall and other people listening, and having this roundtable discussion gives me an opportunity to listen to you. Many of you, I was very glad to hear when we had a brief round of introduction. You have had a long-standing interest in Cambodia. Many of you are working in the area of human rights in Cambodia and elsewhere. So when coming to speak to an audience like this one, I also hope to benefit, take something away from this discussion, so that how I can do my job better. No human being is a perfect one, let alone me. So whatever I am doing within time constraints. When I was appointed by the Human Rights Council, I asked them, look, what's the time commitment required for this appointment? They said, well, around 40 days. But in reality, it has been nearly 3 full months. And as you know, we all work pro bono. And the issues are very challenging. I think 1/3 of my hair gone grey after I became the special rapporteur. So that's the situation. So I would very much like to hear from you. What are your thoughts are? How can the special rapporteurs become more effective? How I can become more effective? What are other challenges? I haven't entered into the work of the Khmer Rouge tribunal, the extraordinary chambers in the courts of Cambodia, which Claire has been very closely monitoring. She has, I'm sure, very interesting things to say. And Heather, of course, has been monitoring the situation for a long time. So there is another whole area of issues there to be dealt with in Cambodia. But again, I would like to hear from you. Thank you for your attention.
Well, thank you very much. Thank you very much. And that was a really very fascinating and comprehensive treatment of the situation in Cambodia, and also the role that special rapporteurs can play, and all the choices that you have to make about how you play that role and be as effective as possible. I know it's brought to my mind a whole bunch of questions that I'd love to ask you, but I think first we'll turn to Claire for some brief comments to either in response or to complement the presentation by the Special Rapporteur, and then we'll open it up for discussion.
Great. Okay, thanks. Thank you for that, Professor Subedi. I think what struck me actually when I was listening to that presentation is, in terms of everything that was touched on almost, you see how those issues are reflected in the Khmer Rouge tribunal itself. So for those of you who don't know, the Khmer Rouge tribunal's been operational now for about 6 or 7 years. This is going into its 6th or 7th year. And there are 4 cases before it. The first case has just been finished, was against one individual, and the appeal verdict in that case was just delivered in February. The second case is against 3 individuals now, and is currently underway. And there are a further 2 cases known as cases 3 and 4, and probably one of the biggest issues, if not the defining issue of this Khmer Rouge tribunal, has related to those 2 cases. So I just want to probably draw on a few things that Professor Subedi said. You know, there are, I think, the issues that are coming up for the Khmer Rouge tribunal. For those of you who don't know, the tribunal is an endeavour, a partnership between the United Nations and the Cambodian government. It has the majority of national judges in each of the chambers in the court, and there are co-prosecutors, one national and one international, and also co-investigating judges. Roughly, it derives itself from the French civil law system, although it's slightly more complicated than that. But decisions about who the court prosecutes are made in the first instance by co-prosecutors who conduct a preliminary investigation into allegations, and then at the end of that they refer what's known as an introductory submission to the co-investigating judges. And those judges are meant to conduct a full and comprehensive investigation into crimes alleged and decide whether or not the prosecution should move forward. When the court was initially set up, the negotiations were extremely difficult and protracted, and for the very reason that the international community knew that Cambodia did not have an independent judiciary and that there were going to be major issues with the decision making around who the court was going to prosecute. And because of that, a number of provisions were built into the instruments establishing the court to try to overcome that. And to varying degrees, those provisions have or have not been successful. And I think in relation to cases 3 and 4, which are currently under judicial investigation still, you can see that the provisions are actually still very problematic. I just want to highlight one particular aspect of this that actually builds on Professor Subedi's comments about the judicial appointing authority in Cambodia, the Supreme Council of the Magistracy, because actually this is the most relevant issue, I think, for the court that's going on right now. As I said, the court has a combination of national and international judges. During the course of last year, as part of our monitoring, and also other organisations and the Office of High Commissioner for Human Rights internally raised many issues about the non-investigation, effectively, of 5 suspects in cases 3 and 4, or at least problems with how those investigations were proceeding. At that point, there was a national and international judge in that office. The international judge was a German by the name of Siegfried Blank. And one of the cases, case 3, was closed prematurely without any real investigation having been carried out. This was in 2 cases that the Cambodian government has opposed for years. It has consistently said that it wanted the court to finish its mandate after the case 2 suspects were, the case 2 accused were prosecuted. I think after a lot of public outcry in what was going on in that office over the course of last year, Judge Blank resigned in October. And the big question at that point was, well, the International Reserve co-investigating judge, who is a Swiss judge by the name of Casper Anserme, was meant to step into that office. There was, as I say, a long history of the government opposing these cases, and actually what happened after that is that the Cambodian government rejected the appointment of this international judge. Under the agreement establishing the court, the government was actually not meant to have any substantive input into that decision. But in quite a sophisticated way, possibly, it delegated that responsibility to this body, the Supreme Council of the Magistracy, and that was the body that rejected his appointment. Now, on that body sits the national co-investigating judge, Yuban Lang, against whom a number of allegations of misconduct were made throughout the course of last year, including by us, and also the national co-prosecutor in the Khmer Rouge tribunal, who also opposed cases 3 and 4 from going ahead in line with the Cambodian government's position. So in addition to general problems with the Supreme Council of the Magistracy in relation to this particular decision about the appointment of an international judge, there were obvious conflicts involved in the decision making because of those individuals who were opposed to the cases from within the court acting in the decision-making process about the international judicial appointment. Where it's at now is that the United Nations special expert, whose name is David Sheffer, who was appointed early this year, took office about a week after the SCM rejected Casper Surmay's appointment, and he came to Cambodia just after the UN released a press statement saying that the Cambodian government was in breach of the agreement establishing the court. And essentially there are just two distinctly different positions on where things are at just now. The UN says that it considers the judges effectively appointed, and the judges in office in Cambodia trying to conduct investigations into those two cases. And at every opportunity on the national side of the court, there is public opposition to recognition that the judge is properly in place. So I might leave it there because I think it's probably a good time to enter into some discussions and for us to answer some questions, but I think I just wanted to highlight especially the judicial independence issue in Cambodia, because I think just by looking at the court, by looking at the Khmer Rouge tribunal, you see how some of these issues are playing out today.
All right, I think if it's okay, I'm going to exercise my prerogative as the moderator here to begin our questions, and then we'll pass it around. And, please come on in and find a seat if you like. I have maybe two questions. I have many, but I'll limit them to two. I think the first is really about maybe stepping back a little bit, Professor Subedi, and thinking about the UN Special Rapporteur role and the human rights system. And I'm interested, I'm intrigued by the way that you've approached this kind of systemic approach, which I think in many settings may make very good sense. But it strikes me as potentially taking you into some difficult territory, legal territory, because you're stepping away from the treaties and the hard law and the very clear norms and stepping into areas of questions of good governance, government structure, policy kinds of, and I'm wondering where you look for the standards or the models and the best practices, and how do you kind of moor it to something that approximates hard law in that effort? Because I think that's, well, I'm attracted to the approach. I think legally it poses some challenges. And then I guess I'd like to ask Claire, one of the promises, of course, of the hybrid tribunals, like the Khmer Rouge process, is that there would be a transfer of capacity, norms, rule of law that would outlast the process. It doesn't sound like that's happening, but I'd be interested in your thoughts on that.
Well, thank you, Betsy. Very interesting question. Well, I did also think very hard before taking the approach that I took. I thought I would be challenged by the government. What authority do you have to look at broader issues of good governance and so forth in the country? But having submitted my proposal, that would be my approach, that I will carry out a systematic assessment of state institutions responsible for upholding human rights, confining myself to human rights issues. The report on the judiciary, of course, judiciary there as a legal entity, and again it has a primary responsibility to dispense impartial, speedy and effective justice. I could have been challenged when I decided to look at the parliament. But again, my approach was, many people came to see me to offer their suggestions, comments with regard to parliamentary reform. I said, it's not about parliamentary reform, about making sure that parliament is able to protect people's rights, always taking a human rights approach to the judiciary and to the legislative body. even with regard to the electoral process and electoral laws, I'm not looking at with a view to making a comprehensive suggestion to reform the electoral process as such, but to make sure that people are able to exercise their right to democratic governance, the right to elect their representatives. So relying on the human rights obligations flowing from hard law treaties, rather than entering into rather controversial soft law territory, which you are absolutely right. I could have been challenged, but I was not. So I thought I would need more freedom of action here. And again, these issues, where do you draw a line between hard law and soft law? Human rights, for instance, right to democratic governance, how do you define it? Who ought to ensure that people are able to exercise their rights to democratic governance? It's the government, it's the executive. So we need to look at the working of the executive itself. Parliament, how are they able to ensure that people are able to enjoy their rights? So always relying on Cambodia's hard law obligations arising from the hard law instruments. That's the approach I have taken. And again, I looked at, because working in a developed country like the UK, very advanced democracy, I also practiced there as a barrister, able to look at the manner the judiciary has been able to perform. For instance, in the UK, it was not long ago, 5-6 years ago, a new body was created to recommend the appointment of judges. One would think that in an advanced democracy like the UK would have a much better system in place for a long time, but again, they are also reforming. I think many of you would know, the Supreme Court of the UK was created 2-3 years ago. So things are happening there as well. And again, in Nepal, where I used to work for the Royal Commission on Judicial Reform, one of the proposals we made even that time was that the body that recommends the appointment of judges should be very independent, impartial and neutral body, consisting of professionals, retired Supreme Court judges, retired Chief Justices, rather than like Claire said, at the moment the composition of the Supreme Council of Magistracy in Cambodia consists of some junior judges who have to take a decision about senior judges, senior to them. How can they be expected to perform effectively if they are members of the judiciary, have to work within the same system, taking actions against your fellow colleagues? Yeah. So that system, I thought, should be improved, applying my own knowledge and experience of work in a developing country and as well as what is happening in a developed country. And I looked at the system in other neighboring countries and then giving them a comparative picture and making my recommendations. I hope I have answered your question. Thank you.
Maybe Claire can answer my second question and you can follow up, Peter.
Yeah, I mean, this is a great point, and of course, the hybrid being in country is really, in a lot of ways, where the future of international criminal justice is at, if not already, with complementarity, etc. My background was actually with the Rwanda tribunal, a wholly international tribunal with a Security Council mandate, and so when I came to the Cambodia tribunal monitoring position, there were things about it being in country that I thought were great, in terms of local engagement that the Rwanda tribunal really did not have or was very limited in. But yeah, I think what the heart of this is, does this enhance capacity building? And of course, one of the concerns that we've been highlighting in that is, what if it is one thing if the court's legacy is neutral or positive, but what if there are negative aspects of that legacy? What if, in spite of United Nations involvement, and which was supposed to guarantee the independence of the court, that doesn't happen overall? We know that there were splits in the co-prosecutor's office along national international lines, in the co-investigating judge's office along national international lines. In the pre-trial chamber, which is another chamber, there have been consistent splits along national international lines on these quite politically charged questions. So there are some other transfer of knowledge activities going on. The court itself is talking about, for example, it's engaged in promotion of fair trial rights in local universities, etc. They're looking at things like using the case management system from the court to implement that in domestic courts and to assist with that. But there are concerning things happening, I think, especially on the core issues of independence that I think are a worry for the contribution the court is making to developing rule of law in Cambodia.
Thank you very much for a very comprehensive discussion. I have a couple of questions. One is, you didn't mention the king, and I wondered whether the king has any kind of a role in this system as being sort of above the fray and having a significant impact. And in part I ask about the king because my sole relationship to Cambodia stems from being a refugee in Kew Gardens, New York, from the Holocaust, together with another young boy who went to Cambodia and who is the publisher of the Cambodia Times and is a good friend of the king's and has opened up something like 500 schools in rural Cambodia, and I help him raise money for that. And he claims that among the biggest issues that he has found, and it probably is something that most of the people here, since they're women, will be interested in, is that the farmers don't allow their daughters to go to school because they need someone to work on the land, and if their sons are going to go to school, which they support, they need someone to work in the fields and so on, so that the girls are not getting an education. This was a very significant issue. I wondered whether you had run into that, and is that a human rights issue, or what is that? And the last question is sort of to you. In this entire issue of what one does with war criminals, is a tribunal of the victors or the outsiders the right model, or must one have representatives also from those who were vanquished on the tribunal in order to have a fair tribunal? Certainly the Nuremberg trials, which was sort of the first example, was a victors' tribunal. Thereafter, they had some of the denazification courts that started getting some Germans in, but I think that the success of any of that has just got to be that the victors are going to be imposing a rule of law, and to expect the people from the vanquished country to participate is not a realistic kind of a model.
Great. Well, thank you. First of all, with regard to the role of the king, I have met with him and then also listened to different views about the role the monarchy can play in the country. Oh, sorry, thank you. The role the institution of monarchy can play in the country. The reality in Cambodia today, that is a constitutional monarchy, the role of the monarch is by and large a ceremonial one. But having said that, the constitution gives some power to the king. Actually, in one of my recommendations, I have said that that particular mechanism should be activated. The mechanism is once a year, the king is supposed to preside over a grand national council, where people from all walks of life can come and express their concerns and grievances about the manner in which the government has been ruling the country. So the king is expected to act as an arbitrator, a conciliator, a guardian for the whole country. Unlike the provision in many other countries where constitutional monarchy exists, the powers in Cambodia are slightly greater for the king. But the king has not been able to exercise that power. Who is supposed to convene such a grand national council? The initiative has to come from the executive, and the executive would like to do that. And can the king, because with the limited resources, without the clear approval of the executive, can go ahead and call for such a meeting? They may not have the courage to do so. As a result of that one, even after having a provision in the constitution for the king to preside over an annual congress, People's Congress, that congress has never taken place. The constitution was adopted in 1993, now in 2012, has not taken place, and I have made a recommendation. This is another platform for people to come together and express their concern about human rights violations. At the end of the day, going back to human rights issues. Since in Cambodia there are so many human rights issues, so prominent issues there are, and people have no platform to express their views. So that is one of the platforms provided by the constitution itself, which has not been activated. Right to, perhaps on the second question, I am not sure whether that's a human rights issue or not. From a broader perspective, yes, it is. It's a right to equality, equal treatment of all men and women, daughters and sons, so and so forth. And again, right to education. We have a special rapporteur on right to education. Right to education, as we understand it, compulsory free education until the age of 16. If that's the case, that right should be available to both girls and boys in every family. That would be certainly a human rights issue. But from looking at it from another perspective, some social issues, social engineering, how you structure your society, how you advance your society. And that's one. Just one thing I wanted to say about what Claire said about the issue of legacy. The Cambodia's Khmer Rouge tribunal was seen as some sort of a role model by many people in the judiciary. When I visited many members of the judiciary, they were finding time. Many people were actually observing the proceedings of the tribunal from their courtrooms and from their chambers. Because a country, judiciary, like any other system, the judiciary itself had to be built from scratch. Everything was destroyed. Only a handful of lawyers and judges survived out of hundreds of them. They were killed. So when the judiciary was being established, who do you appoint as judges? Anybody who could read and write. Actually, some of them were school teachers. They were the only ones who could do some job for the judiciary, as judges. Once you have no other lawyers, judges surviving, so actually some of the senior members of the judiciary today have no legal qualification, no legal training. Maybe in service training, but no prior legal qualification. That's the situation. So for them, what is a fair trial? What do you mean by that one? So Khmer Rouge tribunal, backed by the United Nations, consisting of international judges, living up to the highest threshold possible, so that the judiciary would be inspired by it. But the way things have gone on since then, political interference and number of other issues, people are now becoming doubtful whether it will provide some sort of lasting legacy. But the idea at that time, capacity building, leaving some legacy for the judiciary, when it is trying to grow, when it is trying to develop, that would be a model to follow. But that model itself has so many problems now, which we heard from Claire. Thank you.
Other questions?
Thank you to you both for your talk, and I have a question for Professor Subedi.
Yeah.
My question is about using sort of regional models for looking at human rights, sort of that you touched upon this, looking at the neighbors like Thailand or Vietnam, and I was just wondering how you do that. Do you use it as models? Could you use it as pressure or reciprocity in terms of looking at rights? I know one of the issues I mentioned before, for instance, was Vietnam recently gave citizenship rights to some Cambodians on the border. And so I thought that was interesting, and what would be the potential for reciprocity for the Vietnamese minority there, then 9+%, in getting citizenship rights, and also just sort of also the ASEAN human rights instrument, sort of what the challenges and opportunities you see there. You touched a little bit also on the idea of human rights being a Western concept to some, and you're using the sort of the hard law and the ratification of treaties, but sort of what are the other challenges that you face, and sort of that notion, maybe you can delve a little bit into that. Thank you.
Well, thank you. That was an interesting question. With regard to regional models, I'm not necessarily going to recommend that a particular model be followed. Giving some examples, best practices from within the region. Some examples. That's what I would limit myself to. That's one. And with regard to granting of Vietnamese citizenship to the people living along the border, which is new to me, I hope if this is going to be replicated. It could be replicated with regard to the people called Khmer Rouge, living in the south, who have not been actually, whose issues have not been examined that carefully by any of the international institutions. Khmer Rouge are a group of people of originally Khmer origin, Cambodians, but now within Vietnamese territory. So I hope if that process continues, that issue will also be addressed one day. The other thing is whether countries like Cambodia or other Asian countries could challenge some of the human rights concepts and principles. My opinion has been from the very beginning, no matter which religion it is, if you look at without any preoccupied mind, without reading rather corrupted versions of religious scriptures, the core message in most civilizations is more or less the same. Maybe Western thinkers and Western leaders were instrumental in drafting the Universal Declaration of Human Rights. But since the developing countries gained numerical majority within the General Assembly of the United Nations in the mid-1960s, since then any human rights instrument adopted has the support of the developing world, which includes the Asian countries. So something which you yourself have been responsible in putting together, you yourself are an author of that human rights instrument, then how can you say that it is Western? That's one thing. The other thing is, whether it's a Western or non-Western, that's the way chosen by the United Nations to advance our human civilization. That's the way chosen to bring about peace and prosperity for millions of people around the globe. Once you have chosen that path and decided to join the United Nations, then you have an obligation to fulfill the commitments that you have made through your acceptance of the Charter of the United Nations. The origin may be Western, but today it has become truly global. It represents global values. Human rights values are global values. And Cambodia is a member of that global community. If you are a member of that community, then you have corresponding obligations. You are very welcome to join and withdraw from a cricket club or any other club. But as long as you are a member, you are supposed to abide by the dress code and other codes, etiquette, so on and so forth. And the same thing is with the United Nations. You have joined the club, abide by the rules of the club. That has been my response. The challenge for countries like Cambodia, of course, very many developing countries. The debate is whether civil and political rights come first or economic, social and cultural rights come first. And that's the debate in Cambodia as well. Whenever I go, the Prime Minister keeps reminding me, look, Professor, what you are looking at, merely civil and political rights. You have not given us enough credit for the good work we have done in other areas. Indeed, they have done. For instance, the United States State Department publishes its own human rights reports, annual one. They have given credit to the Cambodian government for enacting laws, enforcing laws vigorously to eliminate trafficking in women and children, prostitution, so on and so forth. The good work has been done. I have given credit for that one. But again, I keep reminding them, my job is to identify the deficiencies. The good thing you have done, well done. But again, there are a number of other shortcomings here. Actually, the Prime Minister said to me, you are friendlier and more diplomatic, but in terms of the delivery of your message, you are no different from your predecessor. And I said, Your Excellency, whether it's me or somebody else coming to the job as a special rapporteur will convey the same message to you. That's what my response was. And the challenge for this country is understanding that without guaranteeing people's civil and political rights, whatever economic development you may be able to achieve may not be equitable one. We are talking about equitable economic development. Equitable can come about by respecting people's dignity, by respecting people's civil and political rights. Both things should go hand in hand. Economic development doesn't necessarily mean that you have to make compromises with regard to human rights issues. That's the understanding, perception in very many developing countries. Oh, we have to do this one. Well, there are a number of ways of doing it. In very many countries, we know that the main objective was economic development. After achieving certain level of economic development, they have come to regret that they did so at the expense of so many other societal values. So our responsibility is to remind them that these are your obligations and those should go hand in hand. That has been my approach. Thank you.
Thank you. Why don't we maybe pass it around and take 3 or 4 questions and then come back to the speakers?
I had a couple of specific, I think it's one each, specific questions for Professor Subedi. I was wondering, I was involved a couple of years ago in the revival of the Asian African Legal Consultative Organization, the UN, which of course, I'm sure you know, has permanent observer status. And I was wondering whether Cambodia has participated at all in that, because it may go, you know, it provides a forum for the Asian and African countries to compare agendas, compare notes on what's going on, and I was wondering whether it might be helpful for them. And for Claire, I was, a few years ago I actually did some research on the Cambodian tribunal, I think actually for OSJI, on the topic of witness protection. And I was wondering if you could speak a little bit about how that has improved or not over the past couple of years.
Well, thank you. With regard to the...
Because time is running short, we're going to gather a couple of questions. You guys can keep track of them, and I'll try and do the same and remind you.
Yeah.
First of all, thanks for coming, for the both of you. I didn't get a chance to introduce myself. My name is Kip Hale. I'm a senior counsel at the ABA Center for Human Rights. And for 2.5 years, I was a prosecuting attorney at the Khmer Rouge Tribunal. And I was on the trial team that was under the watchful eye of one Heather Ryan here. I just wanted to add one comment about the legacy passing along rule of law, and then a quick question, that dovetails off some of the things you've already said, Professor. One thing as OSJI's report said, that case file 1 was lived up to international due process and fair trial rights standards. And I think that actually speaks volumes about passing along the rule of law. That's actually a multi-year process and had many complicated issues of mass litigation. Within the office, we had a very strong policy of having Cambodian legal interns. We worked constantly. We never shuttled off into teams or just international Cambodians. We always were working hand in hand. And I think it paid out in the end, where certain things went forward in case file 2 that were difficult. And also, I think it led to a very amicable disagreement on case file 3 and 4. So I think the system worked in that way. And also a note that I think goes even bigger to all these things I just talked about is over 100,000 people have attended the trials, which dwarfs that of any other tribunal. Having worked at the IC2I, the Yugoslav tribunal myself, I think that's probably one of the biggest things. My quick question was something you were talking about, highlighting the positives. There's few positives that happen in Cambodia, and I just was not just only discussing in reports, but I was wondering any words and deeds that you've done to highlight these examples, because I think it actually has a positive impact, the opposite side of naming and shaming. Thank you.
Hi, thank you very much for a very interesting presentation. But I just have to make one comment. Having been involved with Cambodia for over 40 years, you're not really talking about Cambodia. It has never been a nation of laws and rights. It's a nation of personal relations. The whole culture is based on that. It's been, but the French came in 1863. It's been 150 years, and nothing much has changed. Things still run the way they've always run in Cambodia. It's a very resistant to change Cambodian culture, and I think the Khmer Rouge Tribunal is coming to the point where it's becoming show exactly what the situation is. You're not going to change Cambodia in any short term, certainly on this level, the legal level. And I think, unfortunately, it's likely that the tribunal is going to end in some sort of failure. I'm not exactly sure how that's going to turn out, but Cambodians are not going to allow cases 3 and 4 to go forward because they are concerned that will create security problems. And as a country that's been in turmoil for over 30 years and has a several hundred-year history of turmoil of a similar nature, they just are not going to allow anything to happen that might incite something like that to arise again. So that's what I've got to say. Just try to put some realism into the discussion.
All right, pass it around.
just very quickly, I think I'm a little more optimistic and want to kind of reiterate some of the positive effects of the first case, the Doi case in particular, the participation of many Cambodians in observing the trial or listening to the trial. But having said that, my question for you, Claire, is what you think the Doi appeal judgment, the impact of that judgment on what we can maybe say is a part of the positive legacy of the tribunal.
Any other questions? All right.
Okay, I will
You
have
take
to
them
brief.
in whatever order you like.
Okay, thank you. Okay. First of all, I will take the questions in order they were put to me. ALCO, well, ALCC, that's what it was known, Consultative Committee, which is now a fully fledged organization. Within that one, a great deal of work has been achieved. Actually, the Kathmandu session of the ALCO, I was instrumental in organizing it when I used to work for the Ministry of Law and Justice, which organized the Kathmandu session a long time ago. I've been following their development since then, also in my capacity as the chief editor of the Asian Yearbook of International Law, now the Asian Journal of International Law, published by Cambridge University Press. We do monitor the situation that goes on within Asian countries and within institutions which have something to do with Asia, which certainly the Asian African Legal Consultative Committee. But the organization has been rather timid with regard to human rights issues. They have dealt with other issues, but not human rights issues, because there are so many pressures there not to go into that territory. So, not a great deal has been achieved. With regard to your comments, yes, I think there are some positive things. As you rightly said, a society which is a bit resistant to change. Some change has been made, some progress has been made. The fact that the first trial completed, the guy is languishing in prison, behind bars, life imprisonment. And you are absolutely right. One positive thing, when you go to Cambodia, everybody is talking about the Cambodia trial. People have gone and seen for themselves what is the trial like. It may not be 100%, perfect tribunal or trial, but much better than what they have seen in their daily lives.
Could I just interject one thing?
Yeah.
I just spent a month traveling around Cambodia, and nobody is interested in the trial outside of Phnom Penh and a few people who were directly involved in it.
Yeah.
So you've been talking to a very select group of people, if you think everybody...
Yeah.
Most Cambodians don't even know what's happening, or where it's happening. They don't know it's even in Cambodia.
That may be the case, but the data speak for themselves. Isn't it? About 120,000 people have visited the tribunal and then have seen those who have an interest. Every media broadcasting live sometimes the tribunal going on in the country. As I said, when I visited some courts, people were watching what's going on, how to argue your case, how to present your case, how to marshal your legal arguments. That I thought was itself quite encouraging. And yeah, indeed, opposite of naming and shaming, that's what I have said. I have given credit where it is due and criticized the governments for their failings. And I agree with you also. It's a society based on patronage and personal relationship, by and large. But the society everywhere is changing. The values are not static. Societies are changing and they are influenced by what goes on beyond the borders. Today, Cambodia, whatever decision they take, is very much informed by what goes on elsewhere. They are mindful of the changes taking place elsewhere. Having worked with a number of people within the government, they are, they may not make compromises on core issues, but again, they are willing to make compromises on other issues. So, for instance, the law on expropriation, making a provision to provide for some sort of compensation may not be a huge amount of money. For instance, these days, people being evicted from that land get about $8,000 to $10,000 in compensation. Getting $8,000 to $10,000 is better than getting no dollar. That's how I see as a positive development. But again, I thank you and welcome you for injecting some realism into the debate. And I'm not talking. And then coming back to the question was for you, Claire. Thank you.
I'll answer the questions in turn as well. First on the witness protection issue. Yeah, there are still definite issues with witness protection, I think. I can probably give a couple of examples. In case 2, really there's only been about 6 or 7 weeks of evidence in that case so far, and I think really there have been some issues with credibility of testimony over the course of that period. And when I say that, I mean that the prosecution has not got quite what it was hoping for, I think, out of some witnesses' testimonies. I've heard that, you know, it's also been raised whether witnesses are feeling afraid to talk about the same things that they talked about in their statements. That's in case 2. In cases 3 and 4, I think those issues are even greater because, as I said, the government's been making it clear it doesn't want those cases to go ahead. We've heard many reports, again, about witnesses in those cases recanting their testimonies during the investigations, or even not responding to requests for, to go and speak with the co-investigating judges now. Also, what is in the public domain is that the issue with cases 3 and 4 is already having some impact on case 2, because many of the case 2 witnesses are also witnesses in case 3. And so if those witnesses have recanted part or all of their testimonies in 3, that raises credibility issues with their testimonies in 2. On the issue of case 1, yes, you're absolutely right. We did say that Duit got a fair trial. Unfortunately, some of that we think was undone by the appeal judgment, and there are a couple of specific issues that we raised with the appeal judgment. Mainly that was to do with his sentence. You'll remember he got a remedy for the 8 years he spent in illegal detention, and the Supreme Court chamber, which is the appeal chamber, reversed that remedy for the violation of his rights for that 8-year period. I guess we were very concerned about that because that chamber is made up of 4 national judges and 3 international judges, and to constitute a majority they need at least 1 international to vote with the nationals. And they got that 1 Japanese judge voted with the 4 nationals. One of the very positive impacts from the trial judgment in Cambodia on Cambodian rule of law development was its recognition that excessive and illegal pretrial detention is a violation of fundamental human rights. And unfortunately, we were concerned that the message sent now by the Khmer Rouge Tribunal's Case 1 judgment undoes that, because the message is that, you know, the court didn't give recognition to that fact. You raising about the Cambodian legal interns, great. As for the 100,000 people visiting the court, we say that's great as well, but outreach is not just about getting people into a court to sit on chairs and observe proceedings. We think that that's only one aspect of it. It's an important aspect of it, but in our report we've raised this issue as well. We would like to see more outreach efforts being conducted by the court in the provinces than what's currently going on. Budgetary-wise, the court's moved from one crisis to the other. It's funded by voluntary contributions, and now is certainly not greatly different than before. So, we're realistic about, that playing in on outreach efforts. So I just wanted to finish by, drawing attention to one piece of data, or 2 pieces of data that I'm aware of the impact of the court on Cambodians. And there are 2 studies that were done by Berkeley, where they surveyed randomly 1,000 Cambodians on the court. And yes, overwhelmingly the data is positive, that Cambodians believe the courts carrying out justice for Cambodia, and that's a great thing. But there were a couple of aspects of that data about rule of law that I think are really concerning, and the data was collected first in 2008 and then again in 2010. And over that 2-year period, what the 2010 data showed is that the faith of Cambodians in the judicial system over that period deteriorated in some ways. It increased their views that if you go to court you have to pay bribes to judges increased, and also that Cambodian government officials are not subject to the judicial system. So I think while overall, yes, you know, Cambodians think this is a good thing, the specific data about rule of law impact in some ways is not as encouraging.
Thank you. If I may just add a couple of words about the work of the tribunal, Khmer Rouge tribunal. First of all, the international community went along with the Cambodian proposal when it was being established. It took a long time to conclude the negotiations. And some compromises were made that time which should not have been made if you are looking purely from rule of law, international standards of fair trial, so on and so forth. But we have to deal with it as it is today. It is there and trying to make the most of what it is there, rather than going back to how we arrived here. Thank you.
Well, thank you very much to both of you. This has been a very interesting briefing and certainly covered a lot of challenges. I think we're fortunate to have you both putting your shoulder to the effort. So thank you very much for sharing with us. Thank you all for coming. If you are not members of the Society, I hope you'll think about joining. We would love to have you here frequently for such discussions. And also think about attending our annual meeting at the end of March, March 28th to the 31st here at the Fairmont Hotel. It promises to be 4 days packed with these kinds of stimulating discussions. And I think there's information about that downstairs. But then maybe in closing, please join me in thanking our speakers for our